The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. We are ready to start with our first case, number 211147, Ponce de Ascencio versus Garland. And Mr. Winograd, we'll hear from you.
Thank you, Judge Harris, and may it please the court. We asked the court to grant the petition for review for at least one of three reasons. First, my clients are not removable under 8 U.S.C. 1182.
Counsel, I don't know if my colleagues are having trouble, but I'm having a lot of trouble hearing you.
Can you try moving your microphone a little closer, possibly?
It's embedded in my laptop.
Right.
That's better. If you stay close to it, I think it'll help us. When you backed off may have been the issue.
Okay. I hope this is better. The first reason the court should...
This is not better. Can I?
Yeah.
Can we pause for a second?
For review for at least one of three reasons. First, my clients are not removable under 8 U.S.C. 1182 A7AI because that provision only applies to aliens who actually seek admission at a port of entry. Second, the board failed to resolve whether the immigration judge lost jurisdiction over the case before he issued his oral decision. And third, the board violated this court's precedent by upholding the denial of the asylum application based solely on an adverse credibility finding and without considering whether the claim was supported by independent evidence. Unless the court prefers otherwise, I will first address why my clients are not subject to the charge of removability.
Can I ask you a question about that, counsel?
Yeah.
Oh, I'm sorry, Judge Rushing, you go first.
No, I was just going to say I would prefer that you start with the jurisdictional question, since that could potentially be dispositive on its own.
Certainly.
If there was no jurisdiction to render the oral decision, then there was no final decision by the IJ. Is that right?
Not quite, Your Honor. We agree that the IJ had jurisdiction to issue the order of removal itself that was issued at the conclusion of the proceedings, and that's on pages 136 and 137 of the record. But we believe the immigration judge may have lost jurisdiction by the time he issued his actual decision, setting forth the reasons why he ordered my clients removed. So we don't dispute that there was jurisdiction to order them removed or that the board had jurisdiction to consider the appeal. We just think that the IJ may have lost jurisdiction by the time he issued his actual decision.
But the oral decision is required, right? So if he lacked jurisdiction by the time he rendered that decision, your remedy would be to go back and have the IJ render the oral decision. Is that right?
Precisely, Your Honor.
So why is the error here not harmless, since we now have an oral decision from the IJ and that we know what he would do if it was sent back?
Well, because, Your Honor, as this court has said, jurisdictional limitations are not subject to equitable or other considerations. The issue is simply whether the...
But counsel, this isn't like a real jurisdictional rule, is it? I mean, we have a rule that once a notice of appeal is filed to the Fourth Circuit, a district court loses jurisdiction, but that's just a claims processing rule. It doesn't mean that anybody loses subject matter jurisdiction. I thought what you had here was basically a regulatory violation. There's a lot of rules saying, jurisdiction shifts at this time, and it seems like really what you have is a violation of 1240-12, because all you got was a summary order, and under this regulation, you should have gotten a full decision. This doesn't fall into the class of decisions that can be done with a summary order. So you've got a regulatory violation, but I don't really see why that wouldn't be subject to harmless error review.
Well, even though it is at core a regulatory violation, the board itself has said that once an IJ loses jurisdiction, any subsequent decision they issue is a nullity. So we would say that under the board's own precedent, anything the IJ issued after that point simply has no effect, and that's why we think the board should have at a minimum. Yes.
I'm sorry. Last question on this. I am what I find tricky about this case is the relationship between the summary order, which you agree the IJ had what we'll call jurisdiction to issue, and then this decision. Because I have read the board cases saying that the decision, if it's issued after the divesting trigger, is a nullity. So, but it doesn't need to have legal effect in this case because there's an order that does have legal effect. So I'm not sure that to say it's a nullity means you can't look at it in reviewing the actual order of removal, which was entered with jurisdiction. Do you see what I'm saying? It doesn't have to do any actual work in this case.
Well, the board has held that when an IJ improperly issues only a summary order, the remedy is a remand. So we would disagree that the board could take the IJ's oral decision into account if it was issued after he already lost jurisdiction. We would disagree with that under the board's, as we read the board's case law.
Do you think?
But on that, go ahead, Judge Rashman.
I was just going to ask if you filed your notice of appeal, say in the middle of the hearing, right? The hearing's not going well, and an attorney walks out and files a notice of appeal. Does the IJ then lose jurisdiction to issue an oral decision at the end of the day?
Certainly not, Your Honor. There would have to at least be a final order from which a notice of appeal could be taken in order for jurisdiction.
But doesn't the the time for appealing under 1003.38 runs from the time of the oral decision. So I kind of read what happened in the board to be that the board had questions about whether your notice of appeal was timely because it was before the oral decision, so the time for appeal hadn't started to run, even though maybe the IJ had misled you about that. And so they weren't sure if your appeal was timely. So they said, well, we're just going to certify it. We're after the oral decision is announced, we're going to certify the appeals for ourselves so that all those potential problems are sorted out.
Sure. The regs send somewhat conflicting signals on this point, but we would point to 8 CFR 1240.15, which says that an appeal shall be filed within 30 calendar days after the mailing of a written decision, the stating of an oral decision, or the service of a summary decision. And that's what we have here.
Yeah, but you admit in your brief that a summary decision doesn't apply to your case. A summary decision is defined at 1240.12b, and that it applies in circumstances that are not your case. You didn't get a summary decision.
Well, we think what we got at the end of the hearing was a summary decision. What we say in our brief is that the summary decision would have been improper, relying just on that.
No, you got the summary of the oral, the same sort of form that you get for an oral decision.
Regardless of what it technically is, the immigration judge made very clear that we had 30 days from the date of that hearing in order to file the notice of appeal, and he issued an order of removal. So, for example, if we had never filed a notice of appeal, that order of removal at 136 and 137 of the record would have given DHS the legal authority to deport my clients.
Yeah, I guess my question is just why isn't what the board did the right response here? They were unsure about whether your notice was timely because you didn't wait until after the oral decision, and so they certified the whole appeal after the oral decision. If you can't divest the IJ of jurisdiction in the middle of the hearing, why could you do it before he announced his oral decision?
Well, we're not sure that that's why the board certified the case itself. That the board certainly didn't explain why it was doing that. We think the likely explanation is that it was a tacit admission that the IJ had lost jurisdiction by the time we filed the notice of appeal, and it was trying to cure that problem. But
Well, but even if that's true, counsel, I mean, you could look at this a bunch of different ways. I mean, the IJ, certainly, did some things that aren't technically aren't in compliance with the rulings, and both in terms of issue an oral decision without the presence, and in terms of the date maybe for the appeal. But on the other hand, petitioners knew an oral decision was coming. And he had said so, and all the language in the June 7th is, I will be doing this, I will be doing that. So, kind of Judge Rushing's point, there's a bunch of kind of things that are irregular, and why can't the board, particularly with something where jurisdiction isn't like our Article 3 jurisdiction, say this is a big mess, but we really have everything we need. I'm going to certify it to take away all those questions and then render a decision. What prevents that?
Perhaps the board could do that, but we have no explanation that is exactly why the board did what it did. The board simply dropped. But we
can't. I'm sorry. Go ahead and finish. I apologize. I didn't mean to cut you off right after I asked the question. Go ahead.
Not at all, Your Honor. I would think we don't. The board never explained why it did what it did. It simply dropped a footnote saying it was certifying the case to itself, leaving this court to speculate why it did what it did. So that's why really our request was simply a remand for the board to squarely address this argument and explain why it was doing what it was doing. But if the court is not moved by that argument, with the court's permission, if I could move to the charge of removability issue. Each of my clients was charged under 8 U.S.C. 1182 A7AI, a provision that applies to aliens who lack proper documentation at the time of application for admission. But as this court has recognized, Congress defined the term admission to require an entry into the United States after inspection and authorization by an immigration officer. By definition, aliens who enter the country surreptitiously do not apply for admission and must instead be charged under 1182 A6AI, a provision that applies to those who are present in the United States without being admitted or paroled. So the government charged my clients under the wrong section of the INA. Now, applying the tools of statutory construction. Yes,
Counsel, I'm sorry, before you get to the merits of your argument, I'm afraid I want to ask you a sort of similar question as to your first issue, which is why any error here isn't also more or less harmless, given that your client stipulated to the notice of appeal, and not just removability, but to the whole thing, which includes an allegation that you're an alien present in the United States who has not been admitted or paroled, which means even if 7 doesn't apply, she is removable under 6. So what is the...
Sure.
Even if we agree with you on the statutory question, why does it make a difference in this case?
Sure. A few responses. One, under Chenery, of course, the court can only affirm an agency action based on the reasons provided by the agency.
Right, but we could say that the ordinary remand rule doesn't apply because it would be futile, because there's no point in sending this back to determine whether someone is removable under A6 if that person has already stipulated to the facts that make them removable under A6.
Well, DHS never lodged a charge under A6 against my client, and there's no guarantee that DHS would elect to do so if this case is remanded. And even if DHS does try to amend the charges, there is a colorable argument that they waive the issue by failing to do so once this case was at the board and we raised the issue. And
speaking of waiver, your client had multiple attorneys who conceded her removability under A7, and there's board precedent saying that an attorney can admit removability or deportability, and that the IJ can rely on that. So, doesn't that resolve the issue?
No, Your Honor, because at the time the board decided my client's case, the Attorney General had held in matter of 8B that parties. But
that's not the law anymore. So we can't reverse on that ground because AB is not the law anymore.
It's not the law anymore, but it was the law at the time. And again, under you have to look.
But we can't reverse
the
on
reasons that the agency took. Well,
hi, sorry.
Yes.
We can't vacate and send it back to the board on the on the ground that it failed to take into account something that's no longer the law, right? That it may have been the law at the time, but it's not anymore. So we can't vacate on that ground. Do you have another argument?
Well, yes, we would also argue that under the INA itself, parties cannot, or IJs cannot make a finding of removability based solely on a concession. In section 1229A, C1A, Congress said that the immigration judge shall decide whether an alien is removable from the United States.
So you'd be asking us not to give. So are you making an argument that we shouldn't give deference to the board's interpretation that attorneys can concede removability?
Well, I believe Your Honor is referring to Matter of Velasquez, and Matter of Velasquez did not involve any interpretation of any statutory provision. And even if it did,
it was an admission of deportability, right?
In Velasquez did involve an admission of deportability, but that case was decided in 1986 before Congress in the 1996 immigration bill added the language I was just referring to, which says that an IJ's determination of removability shall be based only on the evidence produced at the hearing. So by requiring IJs to decide whether an alien is removable, and by requiring that determination to be based only on the evidence produced at the hearing, we think Congress made clear that IJs cannot base a finding of removability solely on a party's concession. If there are no further questions about the concession issue, on the merits, we think that just applying the tools of statutory construction makes clear that Congress intended there to be a difference between aliens charged under A6 and A7. So even aside from the statutory definition of the term admission, the text of 1182 A7AI only makes sense with regard to aliens who arrive at a port of entry. The conference report for the 1996 immigration bill also specifically states that aliens who were previously deportable for having entered the country without inspection would, going forward, be inadmissible under 1182 A6AI for being present without being admitted or paroled. And most importantly, if 1182 A7AI also applied to aliens who entered without inspection, Congress would have had no need to enact 1182 A6AI in the first place. And while it is one thing to adopt an interpretation that renders a word or phrase superfluous, it is quite another to adopt an interpretation that renders an entire contemporaneously enacted provision superfluous. Now, we think it's telling that the government does not dispute our arguments relating to the text and legislative history of 1182 A6 and A7. The government instead relies on section 1225 A1, which says that any alien who is present without being admitted shall be deemed to be an applicant for admission. I see my time is up.
Great, thank you. And you've saved some time for rebuttal. So we can hear now from Ms. Berman-Vaporis. And I apologize if I got that wrong.
Good afternoon, Your Honor. May it please the court. Rachel Berman-Vaporis for the Attorney General. This is a case where the petitioners do not argue that they are admissible to the United States or that the record compels the conclusion that they are eligible for any form of relief from removal. They also do not challenge the agency's adverse credibility finding. Instead, they put forward creative arguments contradicted by statute and controlling case law to argue that they are not removable as charged, despite the representations of 3 of their attorneys. They also argue that this court should remand their case to the board for the board to determine if the immigration judge had jurisdiction to issue this oral decision. But as Your Honor,
Counsel, can I say, wouldn't that? I mean, I find this jurisdiction question very tricky. And wouldn't it have just made everybody's life so much easier if the BIA had addressed the issue? It could have looked at the tapes apparently and figured out which came first. And then if it turns out that the notice of appeal was filed before the oral decision, it could maybe have said, as we've discussed, well, that was improper, but we see no harm to that error. It might have clarified that, the fact that it is not an enforceable order doesn't mean you can't look at it. We, for instance, when our divestiture triggering rule is, our divestiture jurisdiction triggering rule comes into play, we still will allow consideration of documents that are later filed or issued if they will aid the appellate process. I mean, there's a million ways the BIA could have handled this, but the problem is I have no idea what the BIA thinks about this problem. Wouldn't it make sense to remand and just get this record cleaned up?
No, Your Honor, because as the panel has said, remand in this case would be futile. Under 8 CFR 1240.12, a summary decision could not have been issued in the petitioner's case and constitute a decision of the immigration judge. A petitioner can only appeal from a decision of the immigration judge, except in bond proceedings, in order to get a review by the board. So when the petitioners filed their notice of appeal, it was defective, regardless of whether they filed it before or after the immigration judge issued his oral decision, because they couldn't appeal the summary decision because it doesn't constitute a decision of the immigration judge under the regulations.
So, counsel, it sounds like you're kind of going back to maybe some of the stuff we talked about earlier, that maybe this, maybe there was jurisdiction, maybe there was these mishaps and things like that. But we really don't know what the board's reasoning was for its certification. And lots of times generally we require a sufficient explanation in order to follow it. And one of the questions I have is, does that rule apply here to certifications when we really don't have jurisdiction over certification decisions? That to me is kind of what I struggled with the question Judge Harris raised. I would have liked to have seen a little bit more. But on an issue that we don't have jurisdiction over, would the normal ways we might, look at that askew, not apply?
Yes, Your Honor, they wouldn't apply, because since the certification decision is solely committed to agency discretion in this matter, this court couldn't remand and ask the board for more information about that decision. Yes.
But I don't want more information about the decision to certify. I'm 100% fine with the board's decision to certify and just say, look, we don't know what was going on here, but we want this whole case in front of us. Fine. I have no issue with that. That still doesn't tell me what does the board think about the possibility that the IJ's oral decision came in after the notice of appeal. Those seem like two different questions. The certification decision is what gets the entire matter in front of the board, even if there's been some impropriety in the notice of appeal. But it doesn't answer the separate question, I don't think, of whether the IJ either had jurisdiction or didn't need jurisdiction for us to be able to consider the oral decision. And maybe the board thinks it answers the question, but it didn't say that. They seem like two different questions to me. I have no quarrel with the idea that this whole issue is properly in front of the BIA because it's certified and they don't have to justify that decision. But I'm still not hearing an answer to this sort of hypothetical question I have for the board, which is, what is it you're telling me about this possible timing snafu below? And why it's okay for us to look at that IJ, because we need to look at it under your theory of the merits of this case. We need to be able to look at that IJ decision to understand why the board was correct in saying and relying on this credibility finding. But there is a lot of BIA case law suggesting that that decision might be what it calls a nullity. So I kind of feel like I need an answer from the board on that issue.
I believe I understand the distinction you're making, Your Honor. And you're right, the board did not explain that in its decision. But I believe in looking at the regulations, it is clear that regardless of when when the petitioners filed their notice of appeal, because they're appealing a summary decision that didn't constitute a summary decision under the regulations, that the IJ had jurisdiction to issue his oral decision. So there was no need perhaps to further explain that issue. And since the board was able to certify the case to itself and the petitioners got their day in court, and really the board did the petitioners a favor by certifying their case in this, by certifying their case, because they could have merely rejected the petitioner's notice of appeal as defective and sent it back. But instead they took everything because everyone was on the same page. Everyone had the decision and was able to continue to litigate the case. Yes, Your Honor.
Counsel, I'm going to back off right after this because I guess my follow-up question is I don't really see that explanation on the face of this opinion, and it's not 100% obvious to me. But if it is the explanation, as I understand it, you're saying it's clear that this notice of appeal was ineffective because it came before the decision, the oral decision. But I thought there was a point at which the IJ actually says to the petitioner, you'll get the oral decision once you appeal. And if that's what the IJ told the petitioner, then I think if that's what the board is relying on, that's not very fair. Then there's been a real miscommunication here to the petitioner about when the petitioner should file a notice of appeal. And so I would be uncomfortable relying on that ground.
I understand, Your Honor. In that part of the transcript, the immigration judge first said, I'm going to issue my oral decision later today or tomorrow, but outside of your presence, which of course was inappropriate and a violation of the regulations. Then petitioner's counsel engaged in back and forth with the immigration judge, wanting to know, well, when am I going to know the full decision so that I can appeal? And the immigration judge talked to petitioner's counsel about how he was going to issue the decision that day or tomorrow, and petitioner's counsel could come into the court and listen to it. And there's some discussion about petitioner's counsel reaching out to the court administrator to get access to that oral decision. And then the immigration judge also said that if they appeal, they will get a transcript of the oral decision, which happens in every case where there's an oral decision. If there's an appeal, then a transcript is created for both parties. So I believe
so you think it should have been clear to the petitioner, don't appeal until you get my decision, and then once you appeal, you will get a transcript.
Yes, Your Honor. That I believe that was made clear, and that back and forth between the immigration judge and the petitioner's counsel, particularly regarding the court administrator and how to access the oral decision, is what made that clear to me. The petitioners knew when the oral decision was going to be issued and how to access that decision. And as to note here, the board addressed whether the petitioners experienced or established that they experienced any prejudice as a result of the timing of the immigration judge's oral decision, and concluded that they did not, and the petitioners do not challenge that on appeal. So unless there are any
counsel, if you could, I don't want to upset the order too much, but yeah, I think, and we'll probably hear from your colleague on reply because he didn't get to this, even though he flagged it as one of his issues. But yeah, the petitioner says even if you get past all these kind of unusual procedural regulatory issues, you still, he wins on the merits because there was not a sufficient consideration of issues other than the credibility. What's your response to that position?
That the petitioners are incorrect. The board adopted and affirmed a specific section of the immigration judge's decision, which was the adverse credibility determination. But in that adverse credibility determination, the immigration judge engaged significantly with much of the petitioner's corroborating evidence, specifically the testimony and affidavit of the lead petitioner's sister, which is particularly critical corroborating evidence here, Your Honor, as the entirety or much at least of the petitioner's claim is based on the lead petitioner's relationship with her sister. So in making the adverse credibility finding, the immigration judge fully engaged with this essential corroborating evidence. And also talked about the petitioner's husband's testimony, which was also offered to corroborate the petitioner's story. And so when the board adopted and affirmed this portion of the immigration judge's decision, it was adopting all of that section of the immigration judge's decision, which necessarily includes the discussion of the corroborating evidence. So the board did consider the petitioner's corroborating evidence and affirming the immigration judge's denial of their applications for asylum and withholding of removal.
And can you address the, I'm sorry, I didn't mean to cut you off, Judge Quattlebaum, or do you have more on that?
No, go ahead, thank you.
Can you also address the torture issue? Because it really seemed there like the board was just really clear that the only thing it was considering was relocation. As the respondent could be expected to relocate, she has not met her burden of proof for this relief. Is it your position that the BIA relied only on relocation and that's okay? Or is it your position that the BIA, notwithstanding that sentence and some others like it, actually did rely on all of the factors?
The latter, Your Honor. While the board's decision clearly spent most of its time on the petitioner's application for under the Convention Against Torture on the issue of internal relocation. In their discussion and analysis, the board also specifically relied on other factors separate from internal relocation, specifically that the petitioners did not establish that they experienced past torture, which is another factor under the regulations that has been specifically enumerated for the agency to consider, as well as the fact that the petitioners experienced and feared harm from private individuals, which is particularly important to an analysis under the Convention Against Torture, and that petitioners had other similarly situated family members still living within El Salvador unharmed. And again, since protection of the Convention Against Torture is future-looking, since the similarly situated family members were also members of the petitioner's pro-offer particular social group, this was relevant to the analysis. So while the main thrust of the board's analysis was indeed on internal relocation, the board clearly considered other factors in coming to this decision, and so did not solely affirm the immigration judge's decision denying protection under the Convention Against Torture on internal location alone.
Thank you.
Well, counsel, just to follow up on that, let me just, if there is sufficient evidence supporting the relocation issue, assuming the petitioner wins on everything else related to CAT, would that still be enough to justify denying that request for relief?
If the agency weighed all the evidence relevant to a consideration of an application of protection against torture, but in weighing the evidence concluded that petitioner's ability to internally relocate weighed against granting that application, then yes, Your Honor. The agency couldn't only consider internal relocation. The regulations are clear on that. But if internal relocation is the factor that weighs most heavily in favor of granting or denying an application, certainly that is acceptable and appropriate. Unless there are any other questions regarding the merits of the petitioner's applications for relief at this time, I will briefly discuss the petitioner's charge of removability. The agency properly concluded that petitioners were removable as charged under 8 U.S.C. 1182 A7AI as immigrants who at the time of application for admission were not in possession of a valid entry document or other suitable travel document. First, the petitioners are removable under this section because they conceded through counsel not once, but on 3 occasions that they were removable as charged. And I must disagree with opposing counsel. An immigration judge can conclude that a petitioner is removable solely based on a non-citizen's admissions. This can be found in the regulations at 8 CFR 1240.10c, which provides that an immigration judge can determine petitioners removable as charged based on petitioner's admissions if they're satisfied that no issues of fact or law remain. Excuse me. The immigration judge's decision indicates that he not only concluded that the petitioners were removable as charged based on their admissions, but also on his own review of the evidence. Petitioner's counsel, in making their representations to the immigration judge about removability, did not raise any issues of law or fact regarding removability at that time. Moreover, it's important to note that since the petitioners admit that they have not been admitted to the United States, it is their burden to show that they are admissible. And so in pleading to the notice to appear and responding to the immigration judge, that was their opportunity where they needed to bear their burden. And by conceding to the immigration judge that they could not bear that burden and that they were removable as charged, these are judicial admissions. As the petitioners do not argue there's been any ineffective assistance of counsel. Yes, Your Honor.
I want to make sure I'm understanding. I think I understand the arguments you made, but at the beginning, is it your position that aside from admissions or concessions and estoppel and stuff like that, that the A7 provision was a proper provision under which they could be removed?
Yes, Your Honor.
So even if, forget concessions, anything else, even though the A6 may be the one that might apply more directly, or maybe you don't even agree with that. You think that the A7 provision applies as well?
Yes, Your Honor. Matter of MDVC, which is a presidential board case, makes this clear. The facts are very similar to the facts in the instant case. In that case, like in this case, the petitioner's notices to appear allege that they entered at or near a point of entry. They conceded alienage before the immigration judge, and they were apprehended by the government. Yes, Your Honor, Judge Harris?
Counsel, I agree with your reading of that BIA case, but I mean, I'm counting 3 circuits that have disagreed with that and don't think A7 would be an appropriate ground of removal in a case like this where someone hasn't presented themselves for inspection. And at least one of them said, and that is unambiguous, so there is no deference owed here. So do you want us to I mean, I suppose what you're asking us to do is just disagree with those circuits. Are there any circuits coming out your way?
I have not found, apologies, Your Honor, I've not found a case in the circuit courts that have abrogated matter of MCDV or have said that this charge does not apply to the petitioners. There's no port of entry requirement in the plain reading of the statute of the removability position in 7, Your Honor. Later in the statute, 8 U.S.C. 1225A1 defines applicants as admission as anyone who's entered the United States without being admitted.
I mean, just to be clear, I would never just kind of like try to surprise you with a bunch of independent research. I just was looking at the Torres decision, which itself cites 2 other decisions, which have nothing to do with the Northern Mariana Islands. And it's one of those decisions, and I'm sorry, I can't remember which one, that expressly says, and the reason we're not giving any deference to the BIA is because this is an unambiguous statute.
Well, I apologize, Your Honor. I'm not familiar with the cases that were cited in Torres v. Barr, but in that Ninth Circuit case. But in that Ninth Circuit case, so much of the court's holding was based on the unique situation in the Commonwealth of the Northern Mariana Islands, because when the petitioner in that case first entered, yes,
is that actually the government's position? Is this the position the government is taking in the Ninth Circuit right now, that non-citizens can be removed under subsection A7 even if they haven't applied for admission and presented themselves for inspection, so long as they are not from the Northern Mariana Islands? The government is reading that decision as limited to that class of non-citizens?
Your Honor, the government is reading the holding of Torres v. Barr as saying that A7 was not appropriate for those particular non-citizens, really? Because at the time they entered the territory of the United States, the CNMI, that requirement did not exist. Whereas here, when petitioners entered the United States, that requirement did exist. And under 8 U.S.C. 1225A1, anyone who enters the United States without being admitted, whether or not that is at a designated port of arrival, is an applicant for admission. And Congress has spoken here and might perhaps a little counterintuitively said that applicants for admission are a very broad category and meant to be applied expansively, which the board has held in numerous presidential cases for the last decade at least. I see my time has expired. So
thank you.
Thank you.
Oh, I'm sorry. Do my colleagues have questions? I didn't mean to cut anyone off. Judge Rushing, Judge Quattlebaum?
I'm good. Thank you.
Thank you very much. Mr. Whitten. Oh, just waiting for the clock. Forget.
Thank you, Your Honor. On the jurisdictional issue, I would just point out that if the court does remand the case to the board to clarify this jurisdictional question, that itself could lead to the resolution of the other issues in this case. For example, DHS could use the remand to amend the charge of removability, and or the board could amend its prior decision to address the errors we believe it made in denying my client's applications for relief. So sending the case back to the board just to clarify this jurisdictional issue could potentially forestall the need for any further litigation. I would also note that on the certification issue, this court has not spoken yet on whether it has jurisdiction over the board's decision to certify a case to itself. That's an open question in this circuit. It typically arises when the board denies an alien's request for certification, but we did not make such a request in this case, that the board simply certified it to itself through sua sponte. So that issue has not fully been briefed, and we would ask the court to not reach it. On the charge of removability, the government mentioned matter of MDCV. We would point out that in that case, the board relied on the Ninth Circuit's prior decision in Minto versus Sessions, and that's the very decision that the Ninth Circuit would later unanimously overrule when it went on bonk in Torres versus Barr. So matter of MDCV reflected, yes, Your Honor.
What do you make of the attorney points out, the attorney for the government points out that with your, in addition to conceding removability, that you didn't raise any question of fact or law to the IJ. So the IJ could be satisfied that the law, as applied here, requires or allows him to accept these admissions and says that your clients can be removable under A7A, and no one made an argument to him otherwise. No one preserved any sort of, no one argued to him that he should read the law any other way. So why would he think there's an issue of fact or law left to be resolved?
Sure, Your Honor, a few responses. I think the problem with the argument about the factual allegations is that the factual allegations in the NTA do not actually align with the legal components of 1182 A7AI. While the charging documents allege that my clients did not possess valid entry documents, they do not allege that my clients were applicants for admission or applied for admission. And even if they did, our argument is that whether they were applicants for admission is precisely the type of legal conclusion to which they could not have validly stipulated. If I could make an analogy to the criminal context, immigration courts are not subject to Rule 11, the federal rules of criminal procedure. But we think if in the criminal context, for example, if someone was charged with murder, but there was no allegation that any person had actually ever died, we don't think a district judge could accept a guilty plea without any sort of allegation that anyone died. We think that's what's analogous here, even though the underlying legal analysis is more difficult. There is simply no allegation that my clients were applicants for admission. And then just returning to the point about MDCV, that because it relied on Minto, it reflected the application of then existing circuit precedent, not the board's independent analysis. And we think, needless to say, this court is not required to defer to the interpretation of another circuit, especially when the full circuit later found that interpretation to be incorrect. And because the board didn't provide any independent analysis in this case, even Skidmore deference would be unwarranted. I see I'm out of time, but if the board has further questions, I'm answering them.
Anyone have any questions? All right. In that case, thank you both very much, counsel. We very much appreciate your presence. We are sorry we cannot greet you in person, but thank you and be safe. And we'll now hear our next case. States versus Perez, and Mr. Smith, we'll hear from you.
Thank you very much, Judge Harris, and may it please the court. The issue in this case is how much time can a person be put on supervised release after being convicted of under 21 U.S.C. 841 and 21 U.S.C. 841B, B1D. There's the current law, our argument is the current law says that the maximum amount of time is 3 years. I think the government has just asked the court to change that based on language within 841. Notwithstanding, we think there's three primary arguments why the law should stay the same. Those arguments are based on plain meaning of the statute and strict construction principles, precedent and case law, and the little bit of congressional intent that we have, we think is in our favor as well. As far as the plain meaning of the statute, there's clearly a statute here, 18 USC 3583, that sets maximum amounts of time for supervised release in cases, and in this case would be 36 months. I can go through the analysis if the court wishes to, but I think it's in the paperwork. And then in 841, there's a minimum amount of time. And so we think that it's clear. We think that there's language in 841 that says notwithstanding 3583, but it doesn't set any maximums. And we would point out that in 21 USC 841, it actually sets maximums on other things. For example, imprisonment on a B1A charge may not be less than 10 years or more than life. So it's clear that Congress could set maximums if they wanted to. There's not a whole lot of precedence in the district. However, the latest unpublished case, the Davis case, which is mentioned in the brief, found in that same way. And it's based on Good and Pratt, are the two basic cases that were mentioned before. Good is a case that came before the notwithstanding language, but it set out a rationale, and the rationale was basically to try to give meaning to all language, and it set a maximum and a minimum, just like our argument does. Pratt came later, and interestingly enough, Judge Rushing.
You are of course right that we've read some of these provisions in perhaps ways that are difficult to reconcile. But it looks like no other court of appeals is reading them that way anymore after 2002. So why should we stay alone out here in the potentially erroneous pre-2002 case law?
So Judge, first of all, I would give you two answers for that. First of all, I don't think that the cases in the other districts are as clear as the government's brief makes it look. There are certainly some districts that say, yes, this is our ruling, or because of the notwithstanding language, we have changed our ruling. I think the Kelly case and the Jackson case in the Fifth Circuit and the Ng case in the Second Circuit definitely do that. But most of these cases, and all of the cases cited by the government, they're not B1D cases. They're B1A or B1C cases. And that's important because in those cases, they have the same amount of time for the maximum and minimums under both statutes. And it doesn't have that for the B1B cases and the B1D cases, which is what we have here, a B1D case, of course. And that's a big difference because in those cases, in our district, Good have found that Pratt found that because they're the same, there's no reason to give meaning to the language. And that same rationale was used in other cases, both in the district after 2002, but also in the other districts as well. And some of them were just summary arguments. So I don't think it's as clear as
Counsel, can I just follow up on your distinction between the A and C and B and D?
Yes, Judge.
If we read it that way and basically follow the rule of Pratt, do you have a response to what Pratt itself identified as, I think what are called anomalous results, which seems like a bit of an understatement, that you would end up with some of the less serious offenses having a maximum of life, but the more serious offenses being capped at 3 years or 5 years? I mean, do you have a theory for why Congress could possibly have intended that result?
Judge, I don't think there's a theory that says why they intended that result. I think it's more likely that they did not intend a result at all, and because of our construction, we have made these results. I would say that you can look at it the other way and say, did Congress intend to give a maximum of 5 years on a B1D offense, but then give the courts permission to give them supervision for the rest of their life, which would be a very incongruous kind of decision as well. So you can look at it the other way.
Well, I think you would resolve that incongruity maybe by saying that, I always get my sections mixed up, just a minute, that Section 3583 only applies except as otherwise provided. It's like a gap filler. It's there so that you can sentence to supervised release under provisions that don't themselves have a supervised release provision. So that takes care of that incongruity, doesn't it? It just shouldn't apply to a statute that otherwise has supervised release provisions.
Well, I agree that 3583 says, unless otherwise it says in statute. I would just argue that it doesn't say that in this statute. It says notwithstanding the 3583 these minimums must be required, but it doesn't say a maximum at all. The government is asking you to assume a maximum of life. That's the difference, I would say. And I think it's clear that they can do that. They did it for the incarceration period. And I think also that, had they wanted to do that, there's plenty of people in Congress that could have, written that in such a way that made it very clear that that was what they were intending to do. So yeah, I understand that it's anomalous is what the decisions are, but I don't necessarily think that means that we should change it in such a way that would make it anomalous another way, which is to give these long sentences to people who have very small amounts. It's clear that when Congress made 21-841, they had progressive punishments. That's why there is an A, B, C, D, because it's based on the weight. So if you have more heroin or more cocaine in A, you get more punishment than B, than C, than D. It doesn't make sense that they would then turn around and say, well, we're going to give you this lifetime imprisonment. So I mean, I think that the
well, counsel, if I could interrupt, I mean, I realize that the absence of a cap would mean, perhaps the ability to go to life, but I mean, the progression that you're talking about is kind of, also in 841. I mean, it changes. I mean, the numbers go up, as you go through the various subsections there. So I mean, some of that is in both statutes. I mean, I get the argument they could have been more clear that it goes to life, but I mean, we'd like a little more clarity in lots of things, and notwithstanding, section 3583. I mean, I just don't know how you could read notwithstanding 3583 to be anything other than 3583 doesn't apply here. I mean, if we didn't have, some of the earlier cases, I mean, I think we'd look at the plain text and it'd be kind of easy. I mean, and some, at least the main cases before that language was in there. So I'm just having trouble how when with text it's that clear. Do we really have any choice?
So I agree that notwithstanding section 3583 means that this statute trumps that statute. However, the next section of that same sentence is that it shall, some other language, impose a term of supervised release of at least 5 years. So it doesn't it specifically says you can't take the minimum from 3583, which would be 0. It doesn't necessarily say that the maximum should be life. And since there's already another statute that says there's life, we would say that there's a gap in the middle. So we have a bookend, a beginning and an end. That would be the argument. Yes, Judge.
Can I ask you about the House report on the 2002 amendment? I mean, it says expressly, no, these are life maximums, and the whole point of this amendment is to get rid of this crazy good case from the Fourth Circuit and make just extra clear that 841 controls, including that it allows for maximum terms of life. Do you read the report differently than I'm reading it, or is your position that we shouldn't look at the report?
Well, Judge, I do think the report is important for congressional intent, but I would also say that when Congress gets together, they oftentimes don't agree, or perhaps never agree, and that they, of course, did not put in the statute a maximum amount. So I think what the statute says should trump the intent of the report.
Okay, and you think the statutory language is clearly sort of contrary to what's in the report?
Our position is that the statutory minimum is clearly written in 841, and the maximum, there is a maximum written in 3583, and there's not one written in 841.
Okay.
And Judge, I think that good, I'm calling it the good rationale. The rationale used where you have to try to use all the language in there. That's why Good said that you have to use the minimum and the maximum. I think that's used in several of the other cases that were cited by the government. Those cases just happen to be B1A and B1C cases, which have the same amount of time, so that they came to the same result as Pratt. Now, I'm not saying that all of them came that way. Some of them definitely said we find this to set it aside. But I don't think it's clear that all the districts feel that notwithstanding language changed the law. I don't think that's clear from those cases at all. And that's essentially our argument. We'd ask the court to allow us to reserve 2 minutes for a rebuttal, unless there's questions.
Thank you.
Thank you.
Any questions? Thank you. We'll hear from Mr. Gallion.
Thank you, Your Honor. May it please the court. Your Honors, this case allows the court to resolve an issue that, as has been noted during the course of the argument, been resolved in the government's favor by every other circuit that's addressed it. First of all, as to the argument that Mr. Smith made related to the fact that the government's cases were essentially either B1A cases or B1C cases, I would point the court to the Hanley case out of the 10th Circuit that actually was a B1B case. And I think it's helpful because, like the Bailey opinion that Judge Schroeder authored in the district court in a B1B case, it talks about the fact that 3583 has a specific carve-out when it says, except as otherwise provided, related to supervised release. And of importance, of course, is...
Can I just stop you there for 1 second? Because this is a question I had about your brief. So just assume hypothetically, I also find that language very telling. And I think the better reading of 3583 is that it was never intended to apply in sentencing under a statute that has its own supervised release provision. That's what it says, provided, period. But that language was there when we decided good. So what do you want us to do with good? Like, that's an argument for why good was wrong. But, you know, we have good and we are a 3-judge panel, so we can't just say we disagree with good. So what do you want us to do with that problem?
Well, I would argue that good has been overruled by the statutory change in 2002. That the
so you want us to rely on the notwithstanding clause. I mean, that's what we would have to rely on, right?
That's correct, Your Honor. That's correct. And that is consistent with the circuits that considered the issue and decided that the carve-out in 3583 prior to the 2002 amendment allowed for a life sentence or a life term of supervised release as to these 841 cases. And then, as Your Honor, Judge Harris pointed out, the House report as to the 2002 amendment said, we're resolving a circuit split. And that circuit split is the 2nd, 8th, and 9th circuits that say there is a carve-out under 3583 that is the except as otherwise provided language, means that there is no cap on 841, that is drug cases. And so with that, they pointed out that the Good case and the Kelly case out of the 4th and 5th circuits were on the other side, and that they wanted to resolve that issue. And of course, Good, as the court knows, I mean, Good was a B1B case. Now, we have a B1D, as in Delta case, but the rationale is important there because, as Judge Harris pointed out previously, that issue about whether you have 4 to 5 years in the B1B context or 2 to 3 years in the B1D context is one that needs to be resolved and is, I would argue, resolved clearly by both the except as otherwise provided and then the fact that there is the language that amends that statute in 841 to say notwithstanding section 3583 of Title 18, thus creating a clear carve-out in both the B1A context, the B1B context, the B1C context, and the B1D context.
Let me just ask one question, and then I promise I will stop. So I understand your argument, and we really have to rely, I think, given the sequencing here, very much on the notwithstanding clause, because that's what postdates our Good decision. And I think this is what your colleague is saying, and it just seems to me that there's maybe one argument to the contrary, which is that there's a lot of case law saying that what notwithstanding clauses are for is for resolving conflicts. And so if you read the notwithstanding clause that way, it would be saying that, look, post-2002, if there is a conflict between these two statutes, because the minimum under 841 is longer than the maximum under 3583, now we know 3583 controls, notwithstanding the conflict with 841. But if there's no conflict, like in this case, where I think it's the minimum is 2, the maximum is 3, that's great. Apply both. You've got a range from 2 to 3 years. Why isn't that sort of a fair reading of the notwithstanding clause?
Well, I think because it disregards the congressional intent. I mean, if we knew, as we do, that good was at issue and good is a B1B case, thus having squarely in its sights the issue of 5 years is the cap, then that's important in determining that the notwithstanding language is not only for a situation where, for instance, because of an information of prior conviction, the individual had a supervised release term over what they would get otherwise. For instance, in this B1D context, if an individual had a prior conviction that qualified, then they would get at least 4 years. And so that would, to the extent that there is a quote unquote conflict, the court is saying that that's where notwithstanding would kick in. Well, that would make sense, or at least more sense, if the Congress, in deciding to amend 2002 841, used good as the case that was part of the circuit split. Because given that we have good and that it was a B1B case where the person could get 4 to 5 years under the good court's rationale, then there would be nothing to resolve, essentially. Their point
so you need
was,
the House. So you think that reading is inconsistent with the House report, basically?
Yes, Your Honor. That goes against the congressional intent to resolve the circuit split, because in order to give effect to the plain language of the amendment, that would require the court thereafter to allow for up to a life term. And they even say, I think Your Honor, Judge Harris alluded to it previously, the fact that they say, and it's been cited in several of these other cases subsequently, that part of the House report language includes the fact that it says that those longer terms may include lifetime supervised release. That's what they talk about when they say notwithstanding 3583. And so,
counsel, if I could just jump in here, and I appreciate that part of your answer. Do you need, to Judge Harris's question, do you need that language, or does that language just add additional information to the plain language of the text? What if the House report wasn't there and we just had, or let's say there was conflicting stuff so that you really couldn't draw much clarity from whatever legislative history there was, and all we had was the text? Do you think that's enough?
Yes.
Explain why.
I would argue that it is enough, and as demonstrated in the cases since the 2002 amendment that have talked about the notwithstanding language and the fact that it clarifies the fact that there is a carve-out for 841 drug cases, separate and apart from 3583. And so, if the court decided, hey, the House report is not clear enough, or there's not enough congressional intent there, it would still, based on the language of the amendment itself, based on the subsequent decisions from the other circuits, I think indicate that notwithstanding language is, as Your Honor pointed out earlier, a disregard. It's not if there's a conflict, it's a disregard. I mean, the plain language of notwithstanding is in spite of. It's essentially a disregard. That is, despite the fact that there is another statute, doesn't matter, because we have decided that this part of the statute, that is 841, is going to have its own supervised release terms. And they put in the minimum terms, and then consistent with the way Congress has done it in several other contexts, they didn't put a maximum term, and that means the maximum term is life. And of course, I'd point the court to the Turner case out of the Fourth Circuit, which was a 2113 case, a bank robbery case related to forced accompaniment. And they said that in that case, of course, the forced accompaniment results in, if you have a conviction, that it is not less than 10 years. And they didn't say nor more than life. They just said not less than 10 years. And this court said It's a common sense proposition that in construing that part of the statute, that when there is a minimum term provided, but no maximum, that the maximum is life. And that's consistent with other parts of the criminal law federally. 924C, of course, is a not less than 5 years. There's not a maximum term, and that maximum term has been defined by this court as life. Yes, ma'am.
Counsel, if we read, you can read notwithstanding a few different ways. Does it matter here if we read notwithstanding to mean, in case of a conflict only, then we would end up with very kind of wildly different ranges, wouldn't we? We would have, under the same statute, some violations would be subject to a 2 to 3 year supervised release, and others to a 3 to life, and there would, in ways that don't make much sense. Is that something that we should be considering when we're thinking about how to interpret the word here? Should we be looking to what how would it play out so that it's uniform, or if not uniform, at least it results in a statute that makes sense read together?
Yes. I mean, that's an excellent point, Your Honor, in the sense that 841 does not exist in a vacuum. And when you look at, as Judge Motz pointed out in that Pratt opinion, and of course, Pratt was a 2001 case, so it preceded the 2002 amendment. And in Pratt, Judge Motz pointed out in a footnote, this of course creates an anomalous result. And this court has already pointed out the fact that might be one of the bigger understatements judicially. It creates an incredible anomaly in terms of the fact that a person who is convicted of a B1B offense, like Good, is capped at 5 years, and a person who is convicted of a B1C offense, like Pratt, can get a life term of supervised release. And that's clear in the Pratt case that it is life, that under B1C, the term would be up to life on supervised release. And this case came back to the court because Judge Osteen talked about the fact that the courts need clarity. I mean, the district courts need clarity. We've had 2 opinions in this district alone dealing with one on B1B and one on B1D, because the courts are trying to reconcile the language from Pratt and, of course, the subsequent Dawson case, which muddied the water on B1B, and the fact that Davis, in the B1D context, looked strictly to 3583 and said that the max term is 3 years for supervised release, but didn't get into the exception under 3583 for other provisions, didn't discuss the amendment from 2002. And so the court has an excellent opportunity to clarify what supervised release means in 841, consistent with what, as has already been mentioned, what every other circuit has said related to 3583 and 841. This is a great opportunity. And based on the plain language of the statute, based on the cases from all of the other circuits, and some very good opinions within the district courts here in North Carolina, as well as the congressional intent on that 2002 amendment, would ask that this court affirm the decision of the district court. Now, I'll be happy to answer any other questions the court may have.
Any questions? All right, great. Thank you so much.
Thank you very much, Your Honor.
And Mr. Smith, you've got rebuttal time.
You're
Mr.
muted.
Smith, can you unmute yourself?
Thank you. Can you hear me? Thank you. Thank you very much. I would start with the notwithstanding language, which is, of course, the crux of what we're talking about here. Whether it's ambiguous or not, what's clear that different courts have found differently on it. So I think reasonable jurists who know a lot about the case can find different things. I would point out that all of the district court cases that were put in the brief from our district went the same way as Good. You look at the cases from Judge Flanagan, I think it was Davis and a couple of them down there. they found the same way. Judge Osteen did send this case back, but I would point out that the court, this was an Anders brief, the court sent it down to the court to be looked at. And it's the same thing that happened in the Torres brief, the other case that Mr. Gallion has been talking about, was sent back in this district. Those were both sent back from the circuit to reconsider. I would say that it would be difficult to say that notwithstanding is clear to any jurist, any attorney looking at this case when they're reading the statute. And that's what's important, not so much the congressional intent. Congressional intent is important, I would argue, to the extent that we have something we just can't tell what they're talking about. But in this particular case, they did not put a maximum in here. We know that they have situations where they do. And I agree with Mr. Gallion. There's places in the criminal code where they don't do that. You know, I'm not a congressperson. I can't say what best practice is, but it would be easier for us to determine if they did do that. However, I would say when there's an argument about what's clear and what's not clear, that really the strict construction rules, the rules of lenity, this type of thing, really should fall on the side of the defendant. Now, what you're doing here in this particular case, we're only talking about 6 months, but you're talking about the government asking to give judges discretion to put people with minor amounts of marijuana that have been selling minor amounts of marijuana on for their entire life, and put it on no age limit or anything like that, other than, I guess, age of 18 when you become an adult. And so they're asking for actually, they're kind of styling as a clarification, but they're really asking to change the law in a way that is a grab of power. And we got to remember that the guidelines were set in place to try to give similar outcomes to similar defendants across the entire country. And so if we have a range of 0 to life in each of these cases, no matter what the amount of drugs is, we really have gotten rid of any kind of range at that point based on the drug amounts would be our argument. So I would say that. Let's see what else we got here. I would say, and also there was one statement in Davis itself, which of course was the unpublished opinion. The statute is clear, it cannot reasonably be interpreted any other way. That's what a jurist wrote about, this issue. So I don't think it's as clear as anybody would like it to be. I think it's easy to read it both ways, and I think parties have done that. But I think in a situation where it's in that posture, I think that the defendant should get the benefit of the doubt based on the rules of lenity. So that would be what I have to add, unless the court has questions.
Thank you so much. Mr. Smith, I see that you are court appointed, and we are deeply grateful to your service to the court. Thank you both very much. We're sorry we can't greet you in person, but we wish you well, and we hope we will see you in person soon.
Thank you for your time.
K&R Contractors versus Keene.
Thank you, Judge Harris. May it please the court, my name is Charity Barter. I am all right. Should I start over?
Yes, please. Thank you.
So this is, may it please the court, my name is Charity Barter. I, along with Tom Scott, represent K&R Contractors, the petitioner in this appeal. Your Honors, I would submit that the issues before the court today are complicated, but highly important in federal black lung. We've been arguing the issues of unconstitutional appointment and removal protections for a long time. In fact, the entire time I've been licensed as an attorney. So I'm grateful to be here before you today and to discuss our position. My plan, the roadmap for today, I plan to discuss ALJ Bartow's ratification first, then ALJ Applewhite's appointment, then the removal protections, unless the court would prefer a different order. That's how I'll proceed. Starting with ratification, since Lucia, the issue of ratification has not fully been addressed by this court in this context. It's rather unique. The Secretary of Labor attempted to retroactively cure an unconstitutional appointment by ratifying that unconstitutional appointment. The board narrowed the issue to focus solely on the last step of that appointment, which is the hiring by the staff member, which the director and the board and the director claimed to be an agent, that the staff member was an agent of the Secretary of Labor, and therefore that action could be ratified. What we submit, Your Honor, is that ratification is not a solution, because the hiring process itself, the hiring process that purports to be ratified, is unconstitutional. We talked a lot about the hiring process, the competitive service hiring process. What happened before Lucia was the Office of Personnel Management posted job vacancies, administered examinations, interviewed and ranked candidates, and then the agencies would actually pick from the top ranked candidates. The 10th Circuit and the Supreme Court of the United States have found these type of hiring processes to be impermissible under the Appointments Clause, because they create a diffusion of accountability. So we submit, Your Honor, that the Secretary of Labor was not able to ratify the entire process that happened from the time that these candidates were interviewed, examined, and then eventually selected by the staff members. Since Lucia, the process has changed.
Can I ask you, counsel? I'm not sure I sort of struggle with kind of the logic of your argument.
Okay.
I don't think the secretary understood himself to be ratifying the prior process as constitutional. I think he just understood himself to be appointing the ALJ.
Okay.
Why is that not okay? I mean, is it your position that anyone who was once an ALJ, sort of pre-Lucia, cannot be then appointed as an ALJ?
They can be ratified as an ALJ. The new process is very different from what it was before. The old process utilized the Office of Personnel Management to do everything, all the work before.
But I thought they gave the secretary, I'm so sorry, I'm blanking on the name of the ALJs, but they gave the secretary the ALJ's resume, right, and kind of work evaluations, and he looked at that and said, yes, I want that person as an ALJ. So I'm not understanding why that would not be okay post-Lucia.
Yes, I understand your argument, Your Honor. Our entire
It's a genuine question. I'm just having trouble tracking. Yeah.
I understand. Our argument, Your Honor, is that if you really look at the way that everything occurred, the Secretary of Labor could not possibly have had much control over not only the candidates that he chose, but who was in the pool of applicants that he could have chosen from. And so what we're looking at is the entire process. Even in the executive order, the president mentions that the competitive examination process, that it actually takes away from the president's ability to choose who he wants to be in those positions because of the examinations, because of the rankings. And so that's why the process has been changed. So the Secretary of Labor has more of a control over who is able to actually be put in the positions, not just who is the top ranked from the Office of Personnel Management. Does that answer your question?
Probably, yes. Feel free to move on.
All right. So basically, I think that we've put forth that argument. We have said that the entire process is the problem, and therefore it cannot be ratified. Even the Office of Personnel Management is an independent agency. It was not hiring for the Secretary of Labor themselves, but actually many agencies. And so, again, we don't believe that process could have been ratified. Now, of course, if the only issue is the actual person, then yes, Your Honor, your point is well taken, and that if that was the issue, not the entire process, then yes, he could have appointed and ratified that particular appointment. So we're going to move on to, unless there's any further questions on that, we're going to move on to the appointment of ALJ Applewhite, and this one is also kind of a difficult one as well, because the director has said that this is a new appointment, the accepted service. Obviously, as your honors know, after Lucia, there was an executive order by the president that changed the way that these ALJs were being hired, and they were put in the accepted service. Yes.
I don't want to hijack your argument, but I want to ask one question that I think only you will know the answer to. Okay. And I understand you will not agree with this hypothetical, but if we think that the ALJs were properly appointed, but we're concerned that there is a removal protection problem, what, if anything, is your remedy? Does Collins mean that you don't get a new hearing because you haven't made any showing that these ALJs were problematic? Is there any remedy at all for your client, even if we find in your favor on removability?
Yes, Collins has made that very difficult. Our original argument that we believe that Lucia would have been exactly the same for the removal protections is that if there is an ALJ with removal protection issue, that the remedy would be we would get a new hearing before an ALJ that did not have those removal protections. But Collins has kind of changed the landscape just a bit for us. And so my understanding of Collins, and this has just barely come out, so I've only read it a few dozen times. But my understanding is that there are two different issues that we're dealing with, the retrospective and the prospective. Prospectively, there is a removal protections issue. And of course, that is our argument. And so it needs to be dealt with. Now,
Counsel, on the prospective remedy, so are you suggesting that you argued before the board the remedy question, that you put before the board, look, this is the prospective remedy that we would ask for, this is what it would look like, you should sever one layer of protection, keep one, or maybe get rid of both? I mean, I guess what I'm getting at is the board said your entire brief on this, and it's not like briefs have to be long, but the board didn't hear the removal issue on the merits because they said you forfeited it because you can't file a brief that has one paragraph, a citation to a case that by term says it doesn't apply to ALJs, and then just a sentence saying thus the separation of powers is violated, that you didn't ask for a remedy, you didn't discuss the remedial issue, you didn't say what protections these ALJs have under either statute. The board just said, we can't work with this, you forfeited it. Unless that was arbitrary and capricious, how is this question in front of us now?
Your Honors, in my brief, I did speak to that, and I'm sorry, I'm trying to go back here to it.
Well, you disagree with the board. You think your brief was sufficient.
We did.
But I think we would have to say that was an arbitrary and capricious application of its forfeiture rule, and I guess I'm having trouble getting there because, you know, I just as a judge, this is going to sound terribly personal, and I don't mean it that way. What I understand, a very strong argument on the appointments clause, and so that's where you were sticking. And then sort of as a tag on at the end, you said, oh, also maybe removal, but I mean, it doesn't even say what statutory protections these ALJs enjoy. It wasn't clear to me whether you were arguing that it was a dual level protection problem or whether any removal protections at all, I mean, would violate, because the last sentence seemed to be that if they're insulated at all from removal by the secretary at will. I would have had trouble as a judge adjudicating this issue based on your briefs.
I understand, Your Honor, and I think that my answer to that is that our understanding, when we wrote our brief, we did say that the removal protections was an issue, and perhaps we did not explain it as well as we should have. But the issue our main argument is that the Secretary of Labor needs to be able to remove the judge at will. That was
so this is not a free enterprise case. It's not about the dual levels. So you cited one case which is not applicable to your theory of the case.
I just don't understand. Okay.
If this isn't even a free enterprise case.
Well, it is a free enterprise case in that, Your Honor, there were dual protections in free enterprise. But what we were saying is because of the dual protections that the ALJ was enjoying, that
You don't say that the ALJ has dual protections. It doesn't even say that in this brief.
Okay.
I'm sorry, I'm getting all agitated because it can be so difficult sometimes working. And again, I am not critiquing your brief writing. I feel this is terribly personal. I truly understood that you had made a strategic judgment, like we've got a really good appointments clause case and that is what we would like to focus on.
Right.
But having done that, I think it is hard for us to say that the board was acting arbitrarily and capriciously when it sort of held you to that strategy and said, look, you briefed one issue, we're addressing it here on the merits, we're not going to address the other one because you didn't give us enough to go on.
Right. Well, I understand your argument, Your Honor, and I guess our position was that because it was a removal protections issue, is that explaining that was what we had before the court, that free enterprise supported, there should not be a dual protection, so that was enough for us. And the court finds that was not enough. I understand that, but that for us, we seemed like that was. And yes, we did focus a lot on the appointments issue, and that's kind of where we landed. Does that answer your question?
Thank you. Yes, it does. Thank you very much. Yeah.
I'm sorry, Judge Rushing, did I answer your question fully, or was there more to it? I think there was more.
No, I think you were in the middle of answering it. You talked about how Collins has prospective and retrospective. I don't read that to mean like prospective, like how would you amend the statute? They're talking personally for your client, for the employer here. You haven't asked for any prospective remedy. You didn't ask for an injunction or anything like that.
No,
you've asked retrospectively, right, that the decision be vacated so that you don't have to pay the benefits. But is there retrospectively, is there any argument that you're entitled to a redo, basically, after Collins?
That is, it's difficult for me to kind of separate the two, because the way that we see it, Your Honor, is that the judge did not have the authority to make the final decision, to preside over the case. Of course, we have two different ALJs, but also that they didn't have the power because of the inferior officers being insulated from review by a principal officer. That came from Arthrex. So when we have Arthrex and Collins, I guess I'm seeing two different things. What I see is that that our clients and private citizens in general can't have confidence in a system where we don't know who's making the decisions. And with an inferior officer, I know that the Ninth Circuit just rarely ruled on this as well. They talked about the Benefits Review Board having review as well. But the ALJ is an inferior officer, the BRB is an inferior officer, and then we finally get to the principal officer, which is the Secretary of Labor. And what Arthrex said is that the inferior officer needs to be reviewed by a principal officer. And so what we see is that there's really no confidence in a system where we can't tell if the elected official is actually in control and accountable for these decisions. Now, I don't know that I can really relate to you what the compensable harm is, if that's what the court is requiring from us, is that we have some sort of compensable harm. Now, what we have is a client who's being forced to pay money by a judge who doesn't have the authority or the power to make the decisions for the executive branch. And so is that enough to raise to what the Supreme Court has asked for? I don't know, because they really didn't make the decision. They kind of left that to the lower courts. But does that answer your question? Kind of. I'm running out of time, but I hope that does. So since I can't really say much in 2 seconds, thank you, Your Honors.
You've got time for a rebuttal. Ms. Mundell, is that right?
Yes, Your Honor. Good afternoon, and may it please the court, Amanda Mundell on behalf of the Department of Labor. I understand counsel's argument today with respect to the ratification, and I just want to quickly dispel any doubts that the appointments here were not properly made. It seems like petitioner's challenge to ALJ Bartow really centers on the hiring process and whether the secretary could ratify that process. That's not what we're talking about when we look at an appointments clause violation. The question there is simply whether the secretary, who has the authority to make appointments as the head of a department, whether the secretary appointed a particular ALJ, like ALJ Applewhite, or whether the secretary exercises authority to ratify the decisions of his staff members. That's all we're concerned with. And ALJ Bartow here, that appointment was properly ratified by the secretary. In fact, the secretary had the same materials that the department would have otherwise had before him: the resumes, the credentials, experience, and a recommendation, of course, to that effect. So we don't see any constitutional concern with the appointment of ALJ Bartow. And then, as I mentioned, with ALJ Applewhite, that was a direct appointment by the Secretary of Labor. So we see no constitutional problem there. If I may then turn to the heart of the issue, which I think is the removal protection scheme here. I'd like to just take a step back and make sure we're all on the same page about how these different pieces all fit together. So within the Department of Labor, an ALJ exercises that typical adjudicatory authority to review benefits determinations, apply law to fact. Those decisions by ALJs are reviewable by the Benefits Review Board within the Black Lung context. The Benefits Review Board's members are answerable to the secretary. They're removable at will from the board. So within that direct chain of command, there's no question that even though ALJs are protected by this tenure protection of good cause, that the Secretary of Labor and, of course, the President has some authority over ALJ determinations. Now, there's also this piece with the, yes, Your Honor.
Counsel, is this the position in your brief, or does the government have a new position now? Do I not have the most recent brief? The most recent brief I thought I had said that we could sustain this system only if we kind of hobbled the Merit Systems Protection Board. Is that still the government's position?
Yes, Your Honor, and I'm just trying to explain how all these pieces fit together.
Okay.
So,
okay.
Yes, absolutely. So turning then to the MSPB, the way that fits into this scheme is the MSPB's role there is to establish and determine the good cause that the Secretary has identified for removing a particular ALJ. Now, the Supreme Court has long made clear that tenure protections for inferior officers like ALJs are constitutional, and particularly good cause tenure protections. And that sort of means that the ALJs can be removed for misconduct, as the court considered in Morrison and Perkins, for poor performance, and actions like that. Now, the MSPB's role in this system is simply to look at that factual basis that the Secretary puts forward, whether an ALJ has engaged in poor performance or engaged in misconduct, and make sure that that is a good faith basis that's supported by the Secretary's determination. Yes, Your Honor. Okay,
so your brief, I'm sorry, because it will just help me to sort of contextualize this. Your brief is the government's position, but I thought you also said in your 28J letter that you agree with the Ninth Circuit and Decker-Cole. Is that not right?
Yes, Your Honor. Decker-Cole.
Well, Decker-Cole does not adopt the government's position in its brief. Decker-Cole says we don't have to narrow. They're not adopting your narrowing construction of the authority of the Merit Systems Protection Board. They're saying this is just fine on its face. We don't have to adopt any narrowing construction. So I am genuinely confused. And I will tell you why I care about this, because I think if we were to reach the merits in this case, we would need a brief that actually defends the system as it stands without adopting a narrowing construction. And I am wondering, will we be getting that brief from the government consistent with Decker-Cole, or do we need to appoint an amicus the way they did in the DC Circuit?
Well, Your Honor, we're prepared to defend, the constitutionality of Section 7521 insofar as we think that it is properly understood as the MSPB's role here is limited to determining that factual basis for the removal by the Secretary. Now, we agree. If that is not what the statute means, then there really would be constitutional problems here. But consistent with what we've said in our brief, the court has a duty to read this statute in a way that avoids any constitutional doubts. And we think the court can do that. Now, just with respect to the Decker-Cole opinion, Your Honor, we notified the court of that authority because that is an example of the only other court of appeals to consider whether Section 7521 needs to be struck down in any way. And the court there concluded that it does not pose any sort of limitation on the president's authority to exercise executive power.
Right, but it did that without adopting. Sorry, but it didn't adopt your narrowing construction, and I may have misunderstood your letter. I thought you were saying you agree with Decker-Cole, but perhaps you were not.
Your Honor, I think Decker-Cole underscores some of those functionalist concerns about executive power here. The idea being that because ALJ
and that's what I'd like to ask you about. Is so I understand the government's position here to be the government's position in Lucia on this issue, which the court did not address, which is that you need this narrowing construction. But the Ninth Circuit has found that it's fine as it is, and one of the reasons they gave is the function, as you just mentioned, that these ALJs are purely serving an adjudicatory function and not a executive function or a policy-making function. And I wanted to get your thoughts on that, since you are representing the government. Is that right, that they're only adjudicatory? If it's right, is it relevant? And are we looking just at what these ALJs do in black lung cases, or are we looking at what these ALJs do in all the cases they handle for the Department of Labor, including regulatory enforcement and things like that? So, because it's the same ALJ. So that's like 3 questions, but I'll let you determine how you're going to answer them.
Sure. So I'll try to take those one by one. So just with respect to the functionalist approach to the separation of powers question, we agree that, the courts have considered over time, including in Decker-Cole, whether or not the inferior officer is really executing the sort of substantial executive power that the president is, most concerned about. The idea being that if there is severe restrictions on the exercise of that power, then that, of course, impedes the president's ability to take care that the laws are faithfully executed. Now, then Judge Kavanaugh, when he was sitting on the DC Circuit, embraced exactly this approach in his dissent in Free Enterprise Fund. So we think that is at least well supported and is certainly a basis for this court to conclude that Section 75.
But I'm asking about these ALJs, because ALJs across the federal system are very different, and they do different things in different departments, and they have different responsibilities. And so I want to know that these ALJs, is all they do adjudicatory, and are we only looking at what they do in black lung cases? And is the adjudicatory function, is that dispositive?
Your Honor, we think that these ALJs are doing that same sort of adjudicatory role that other ALJs in other agencies do. As far as the black lung context specifically, there's a slightly different review mechanism for ALJ determinations in the black lung benefits review context than there is for other DOL ALJs, but the basic premise is the same. ALJs function to, review these claims. They take evidence, they hold hearings, they apply law to fact. And I don't say any of that to diminish the ALJ's role in the administrative state, but the fact is that they exercise comparatively limited executive power to, the only other example of a dual layer removal case, which is Free Enterprise Fund. So compared to the PCAOB, for instance, there's a much more limited exercise of executive power by ALJs compared to that case. And that is significant, because that is the only other example that petitioner has pointed to where a court has said that the 2-layer removal system interferes with the president's ability to take care.
So should we focus on, or should we also be considering what else these ALJs do at the Department of Labor, that they're not just deciding black lung cases, but they're deciding regulatory enforcement and those sorts of cases? Or are we just looking, and it's a legitimate question, I don't know the answer, are we just looking at what they do in a case like this?
Well, Your Honor, I think, this court could cabin its review to the case like this, and I think that's important because of the Collins implications. At the end of the day, petitioner is asking for a new hearing for this black lung benefits review determination before a new ALJ, and that is so attenuated and disconnected from any harm they've identified. They don't even challenge the substantive determination. So I think this court could certainly look at this context and say, within the context of this case, there's no removal protection issue. But I don't really think that what black lung benefits ALJs are doing is really all that different from other ALJs who are taking evidence and reviewing the record in that way.
I want to make sure Judge Rushing's finished on this point, but I have a follow-up once y'all finish the question answer. Are you good? Are you good, Judge Rushing?
Yeah, go ahead. Thank you.
No, thank you. So, counsel, on the adjudicatory issue, I mean, looking through all the cases on this is quite, kind of hurts my brain, quite frankly. But and that had a lot of, a lot of import on various decisions. But doesn't the Arthrex case go a long way in kind of, diminishing that functional distinction? I mean, I know it's not a removal case in the exact same way, but it seems to pretty directly take on, that they're all within the executive power, and while there can be, functions that are adjudicatory and legislative as well as executive, they seem to diminish that, more so than the law that existed, even in free enterprise fund. What's your thought on how we take that language from Arthrex, in relation to the earlier case about, and I think, both are, I think that's Chief Justice Roberts' case, who wrote free enterprise fund. So it seems to undermine that distinction some.
Your Honor, I don't believe that it does. I mean, I think it's important to consider Arthrex context, where they're looking at removal protection on these administrative patent judges who were subject to a different removal statute and who in any event didn't have sufficient control by agency supervisors and superiors. I think the point here is simply that it certainly is not a question about whether an ALJ exercises legislative or judicial function. They certainly exercise executive power. The question is the president's power to execute the laws so impeded by this combination of removal protections that
I'm sorry to interrupt you, but I mean, I get that issue. I mean, there may be a point that whether or not the other things make the impediment not so great, and that to me is a separate issue than the adjudicatory function issue. But on Arthrex, on the function, it says the APJs, and I know, are still exercising judicial power and must remain dependent on the president. And then it goes on to say the activities of executive officers may take legislative and judicial forms, but they are still exercise of. Indeed, under our constitutional structure, they must be exercises of executive power. It seems like that's going away from that issue, and maybe there's not enough impediment to the executive's ability to conduct his job, but that's a different issue, isn't it, than whether they're adjudicatory or not?
Your Honor, I would agree, and I want to make sure that I haven't misled either you or Judge Rushing in our earlier colloquy on that. I'm not suggesting that this court should focus on whether ALJs exercise judicial power or legislative power. I think it all is intertwined in this executive power context. It's just a question of whether these removal protections so impede the function of the president's executive power. And so I didn't, and to the extent, Judge Rushing, that that was unclear, I apologize. We are not disagreeing with that executive power notion. We simply think that the removal restrictions here, the way that they operate, do not impede that power. And that's the functionalist perspective I'm talking about.
Counsel, I hate to take you from like the sublime of constitutional theory down to the details of this case, but I will for a minute, because I'd like you to address the procedural posture. Do you all have a position on whether the Benefits Review Board properly applied its regulatory exhaustion requirement in holding that petitioner forfeited this argument? And I kind of would expect you would, because that was your argument before the board, that they had not presented this issue in a way that merited a decision on the merits, and the board adopted the board adopted that position. And if they were not arbitrary and capricious, then it's not in front of us. So can you address sort of the procedural posture of this case?
Certainly, Your Honor. And we have not pressed that argument on appeal. We did argue below that was an insufficient way to raise the issue, but we think that it's a pure question of law. This has certainly been briefed at this point.
But we have a million cases saying that if an issue is forfeited before the board, we don't even have jurisdiction to reach it. We're not supposed to reach it. It's forfeited.
And Your Honor, all I can say is we didn't raise that argument on appeal. If this court examines the procedural posture and applies the agency's forfeiture rule and concludes that it was forfeited, that's not something that we are opposing here. But we haven't.
Did you change your mind? I mean, you thought it was forfeited, but do you think now maybe it wasn't?
Your Honor, all I can say is we have not pressed that argument. We think it's an important issue that this court can reach.
And do we have cases saying that even if the agency properly applies its forfeiture rule and holds the issue forfeited, we can go ahead and reach it?
Your Honor, I'm not aware of cases on either end, but it's a forfeiture issue, not a waiver issue. So I suppose there's a possibility that the court can reach it.
Maybe. Thank you.
Your Honor, I see that I'm over time. So unless there are other questions, we'd simply ask that the court deny the petition.
Thank you. And then finally, we have Mr. Austin.
Thank you so much, Judge Harris, and good afternoon to the court. May it please the court. I'm Brad Austin. I represent the coal miner in this case, Mr. Michael Keene. And you've heard three main issues in this case. I would be remiss if I didn't at least just briefly mention the very thing that brings us here today, which is my client, Mr. Keene, who has now waited for, I wrote this down, 4 years, 8 months, and 1 day for a final decision. So while we go round and round with Lucia, I do think it's very important to keep in mind that Mr. Keene does patiently await finality in this case. The solicitor has addressed the removal protections, which we both believe do not deprive DOL ALJs of the authority to adjudicate black lung cases. So I guess I should spend the little bit of time I have left talking about the ratification of Judge Bartow and the appointment of Judge Applewhite. I think a good starting point is that ratification is presumed to be proper. And the burden to challenge that is on the moving party. So in this particular case, even if Judge Bartow was not properly appointed when he first began working as a DOL ALJ, the Secretary of Labor's ratification on December 21st, 2017 cured that defect. K&R argues that the Secretary of Labor rubber stamped the decision because it was made on the same day as receiving the memorandum, but I think your honors have already pointed out that this really doesn't prove a lack of consideration. It proves the importance of the decision. It proves the qualifications of the ALJs. And generally, these courts don't inquire into the agency's internal deliberations anyway. And as far as the cases that employer, or I guess K&R has cited, the Hardin County case dealt with a Texas state constitutional provision, and the LA Tucker truck lines case dealt with a separate issue that didn't involve ratification. So we certainly do not believe they have carried their burden as far as the ratification of ALJ Bartow. And secondly, moving on to the Secretary of Labor's appointment of Judge Applewhite, an appointment by a secretary need only be evidenced by an open, unequivocal act, and that's the Marbury case. In this situation, the Secretary of Labor signed a letter properly appointing Judge Applewhite in 2018. The coal company is arguing that Judge Applewhite's appointment was defective because she remained in this competitive service after transferring to the DOL ALJ. But the executive order K&R cites specifically states that ALJs would be placed accepted service going forward, but those already in it would remain. The key point is that all of these ALJs are subject to the same quote unquote good cause standard, regardless of whether they're in competitive or accepted service. This good cause standard for removal is constitutional. Here, K&R cannot reasonably argue that the secretary did not make an open, unequivocal act. So, Your Honors, unless there's specific questions about any of these three issues, which of course are ratification of Judge Bartow, appointment of ALJ Applewhite, or whether the removal protections are unconstitutional, I believe that the solicitor has already addressed these, and we would just respectfully request that this court take this opportunity because these Lucia-related issues are coming up. I think Judge Quattlebaum said, reading all of these decisions made his head hurt. I have to agree, Your Honor. You know, I'm down in the trenches representing a volume practice of coal miners, and I have to say that Lucia-related decisions are coming up in every single case. So we would just ask this court to squarely address this issue, put this issue to rest, and in situations like this case, like, you know, Mr. Keene, who's been waiting for 4 years on a decision from this court could help clarify some of these issues. So we would respectfully request this court to affirm the decision and order awarding benefits issued by Judge Applewhite and the decision and order affirming benefits issued by the Benefits Review Board. Thank you so much, Your Honors.
Thank you. And I think, Ms. Barger, you've got, I think, some rebuttal time. There we go. Yeah.
Thank you, Your Honor. I appreciate it, Your Honor. Just so that I know that I get to this issue in case the court does address it, the removal protections, I just wanted to address it real quickly, unless there is another question that the court wanted me to answer. But the way that I see the removal protections right now after reading Arthrex and Collins and Decker is that there are really two issues that the courts are concerned with, and that is control and supervision, the control and supervision of the superior, the principal officer. Control through the power to remove the ALJ if the ALJ is not performing correctly or to the satisfaction of the executive power of the president. The supervision through the ability of the president or his head of department to review the decisions that are being made. If you really look at the structure of the federal black lung system in respect to supervision, especially which was talked about in Arthrex, the ALJs are inferior officers. The board members, the benefits review members are inferior officers. And then you have the Secretary of Labor. The board members do, they are at the Secretary of Labor's leisure. What the Arthrex has said, and I thought it was an important remark by the Supreme Court, that the unchecked exercise of executive power by an officer buried by many layers beneath the president poses a constitutional issue. And I think that that's on the supervision area. What we're really talking about is that the Secretary of Labor is not able to really review what the ALJs are doing at the court level, the decisions that they are making. And so that leaves an issue of supervision within the scheme. Additionally, the structure of the federal black lung system in regard to control, this is where we really get to what was talked about with the removal protections, which is section 7521, which permits removal of the ALJ only for good cause determined by the MSBP, and then section 1202, which is the MSBP can only in turn be removed by the president for inefficiency, neglect of duty, or malfeasance in the office. So what free enterprise talked about, and why we quoted free enterprise, is that this is an impermissible statutory scheme which insulates the ALJ. The ALJ can only be removed for good cause by the MSPB, and they determine what good cause is. And then the Secretary of Labor can only remove the SBP for inefficiency, neglect of duty, or malfeasance. And so this we believe to be impermissible, and this is why we believe that there is an issue with the removal protections, because the control and supervision by the president or those who he has appointed with the advice of Senate just aren't able to really control the ALJ. And so we're stating that they're too independent from the principal officers and the president of the United States for him to really effectively take care that he's doing his duty as the president. So those are really the issues that I wanted to address on the removal protections. If there's anything additional that I can speak to with the court, I have about 1 minute and 30 seconds left. I'm happy to answer any questions that you have. All right, well, then thank you, Your Honors. Really what we ask is that you grant our petition, and it's been a pleasure being before you today.
Thank you all very much. We appreciate your time, and we are sorry we cannot greet you in person. We hope we will see you in Richmond at some point in the future. Thank you. And Mr. Leonardi, you're up.
Good afternoon, and may it please the court. My name is Dan Leonardi, and I'm appearing on behalf. Whether a conviction for violating a South Carolina drug statute that sets forth multiple crimes, some of which fall within the scope of the definition of a controlled substance offense under the guidelines, and some of which do not, was properly characterized as a career offender predicate conviction where the lone valid Shepard document fails to narrow the conviction to one of those crimes that would fall within the definition of controlled substance offense. Mr. Boyd was convicted of a drug count under section 841B1C and a second count of 18 U.S.C. section 924C. At sentencing, the district court held that Mr. Boyd fell within the scope of the career offender guideline based on two convictions. A 2006 conviction when he was 18 years old of 5 counts of assault with intent to kill, AWIK, a South Carolina common law offense. In addition to that one, the court found that a 2013 state drug conviction, a violation of South Carolina Code 4453-370B2, also was a career offender predicate. And this first issue deals with that drug conviction. That career offender enhancement at sentencing increased Mr. Boyd's sentence essentially by 3. His bottom of the guideline would have been 90 months. It was increased to 262 months, an increase of 14 years. The first issue presented in this appeal is directed to that drug conviction. The court held that 4453-370 sets forth multiple crimes, some of which fall within, some of them which fall without. For example, referring to the statute of conviction, it contains language directed to distribution and possession with intent to distribute, but it also contains language directed to purchasing. Yes, Your Honor.
Counsel, I just want to make sure we get to the to the Shepard documents, and I agree all what you're saying is important. So I'm not trying to fault you for your arguments, but you said one valid Shepard document. First of all, just what document are you talking about, just so we're on the same page?
The one valid Shepard document, Your Honor, is the sentencing sheet, and I'm happy to discuss what is found on that sentencing sheet.
Okay. So you don't think the I want to go back to the indictment.
Sure.
I understand the indictment may not be dispositive, but is your argument that the indictment isn't valid because it refers to second offense?
That's exactly right, Your Honor. And that's particularly the case when you have a statute like this that contains multiple crimes within this statutory section. That makes it even more difficult to discern specifically what crime is the second offense of, Your Honor.
Well, so does that's kind of was my point. I mean, it seems to me the issue with the indictment, the second offense reference makes it perhaps confusing, and we look to some of our decisions, McLeod and Williams, about those. But there, the difference in the indictment and what the sentence was a difference that mattered significantly. And here, I don't think first or second offense really makes a difference. What makes a difference is whether it's the type of offense within the statute that requires an overt act or not. So I guess my point is I get that the indictment doesn't do that because in the body of it, it contains both types of descriptions. But I may be talking academically, but it seems to me the indictment isn't ineffective. It just may not be conclusive. So then you go to the sentencing sheet, and how does the sentencing sheet with the language after 2: not, provide the indication of what type of offense we're talking about?
Well, Your Honor, that section, as taught by the South Carolina judiciary, is a shorthand administrative summary of the statute. It is designed to include all of the potential crimes under that statute. Of course, it can't include all of them. It tries to do that. There are other CDR code sections like this, including the one that...
It doesn't include all of them. It doesn't say conspiracy or attempt or any of the problematic sections. The only things it mentions are things that would clearly be a controlled substance offense, and your client and the attorneys signed right underneath that saying, yes, this is what he pleaded to. It was manufacturing or possession with intent to distribute.
Well, certainly there are many sections of this to field that are inconsistent with the indictment that Judge Quattlebaum is referring to. So that raises initially a question of how reliable is this particular section, this to field. If you turn to what the South Carolina judiciary says about these CDR codes, it is very clear that this is intended to be a stand-in for the entire statute. There is no other CDR code for purchasing, for example, or for conspiracy. But
that's people write it in. Like, we've had other cases with these South Carolina sheets, and if it's, they handwrite, conspiracy or whatever it is on this line, but your client pled guilty to exactly what's written on the line, so they didn't need to substitute it with something handwritten. Now, I understand that what's on that line includes every drug possible, but what matters for our question here is just, does it qualify as a controlled substance offense? And it does, because it's possession with intent to distribute.
Well, Your Honor, we would submit that what's in that to field is not exactly what he pled to, because if it was what he pled to, then it would have one of the crimes that is set forth.
But does it matter for our purposes? We don't need to know exactly what it was. We need to know that it qualifies.
Well, I guess my point is, Your Honor, and our point is that this administrative shorthand does not make clear, notwithstanding what's included in it, it does not make clear that purchasing and conspiracy are not included when this CDR code is used. When CDR code 0187 is used, regardless of what the person is convicted of under that statutory section, you're going to get that CDR code with those exact characters in it and those exact
So words. We can never rely on the code description. It always has to be handwritten for us to be able to rely on it in any case.
Certainly not. There are many statutory sections that set forth one crime. And so it will be clear that if they're convicted under that statutory section, then it's apparent what the crime is.
But for
Here,
controlled
very
substances, for this one, which covers a whole lot of what's going to come before us when it comes to controlled substances, we can never rely on the code, even if what's written here is exactly what they pled to, because it also happens to match the CDR code.
Your Honor, in the rare circumstances where the entirety of the CDR code is put there, sometimes there's something typed in, and it's very clear, distribution of cocaine base, for example, or something is handwritten in sometimes. But in this particular case, the entire CDR code is used. And this is exactly the same as in the furlough case. The furlough case, also before this court, had also a generic CDR description of the offense. And the district court said, there's no way to tell what specific crime he's been committed of, Mr. Furlow. And so the court stayed the sentencing, continued the sentencing hearing and allowed the government to go get a transcript of the sentencing hearing in state court. And that made clear that Mr. Furlow had been convicted of distribution of cocaine base. Without that, it was unclear based on the sentencing sheet, as it is unclear.
I'm on mute. Sorry, counsel. I'm so sorry. I was on mute. But you were getting at a question I wanted to ask, and it's sort of piggybacking on Judge Rushing's question about just kind of the practicalities of this, because South Carolina does have this one section and the giant run-on sentence that covers basically all drug offenses. So this is an issue. And I am wondering, and I will ask your colleague this too, if you have any sense for in how many cases, how big a problem this is, in how many cases we have only the generic code language here, and it does appear to match up, identically to the generic definitional language. We have only that. The defendant didn't plead as indicted, in which case you could look at the indictment, and there's no plea agreement and there's no plea colloquy. I mean, is this a large, are we going to be, if we adopt your reasoning that this generic language really tells us nothing, are we going to be stuck with a lot of, do you have a feel for, is that going to be a lot of cases? Is it going to be just a few cases? What are we talking about?
It's not many cases at all. And in fact, the other cases that have come before this court have had one of those other Shepard documents, transcript, or whatever, that did make it clear. In those cases, of course, whether the statute was divisible was at issue. That has been decided by this court. So it is not something that is going to come up, in my experience, very frequently. It is a unique set of circumstances in this case that result in the impossibility of determining exactly what Mr. Boyd was convicted of in this case.
So, what can I
go ahead, Judge?
I'm sorry. One thing I didn't think your brief addressed, but if you know the answer, when we're doing this kind of modified categorical approach and we're looking at potential Shepard evidence, how clear does the evidence have to be before we can say, yes, we know what this person pled guilty to? What's our standard here?
Well, it's certainly the government's burden to prove by a preponderance of the evidence that the person was convicted of something that is categorically a controlled substance offense or a crime of violence. And in this instance, we submit, it's just you're not able to tell based on this sentencing sheet. And we can't resort to, we submit, looking at any other Shepard documents because they're not valid based on this court's holding in McLeod. And, in McLeod, the two, what was originally charged and what Mr. McLeod pled to, were very closely related. Two burglary sections, very closely related. And the government in that case argued, look at the daggum indictment. It says clearly that Mr. McLeod went into a building, and that would have decided the issue before the court in that. Yes, Judge Qualley.
And I just want to get real quickly with the arrest warrant. I know the district court I think that was in the PCR. The district court, I don't think, talked about it, and maybe it's a little academic there. I'm familiar with our cases that talk about the affidavit language and what it says about that. So I don't want to talk about that. But on the left side of it, there's an offense listed, and maybe that is your argument for that. Because we do say in, I think, Prudencio, that there's an indication you can use an arrest warrant. Then we got other cases that say you can't use an affidavit. but this is not in the affidavit. Is your argument on that the same thing as the language following 2 in the sentence code, or is it something else?
No, Your Honor. As I interpret this court's law about the use of affidavits or warrants or that sort of thing, is that it has to be incorporated expressly into the indictment in order to be a legitimate Shepard document and a reliable court document.
Okay.
No, I'm fine.
But let's assume we can consider it. I mean, does the language next to offense in the arrest warrant, which isn't part of the affidavit, does that clarify what you're in any way help inform what we're talking about?
Your Honor, if it was a Shepard document in this case, then certainly it could be considered. But I know that sort of begs the question, perhaps.
This does leave me, and this is just like a very kind of basic thing that I must be missing. I don't understand, even if we knew exactly what he was arrested for, how would that tell us what he was convicted of or what he pled guilty to? I don't think it necessarily would. I mean, what he was charged with not necessarily. Like, we can't assume that everyone who's arrested for one thing ends up convicted of or pleads guilty to that. I just...
Sir.
When we're doing Shepard, like, the point is we're looking for evidence of exactly what are the elements to which this person pled guilty or was convicted. And I'm just not understanding how it's even sort of relevant evidence what they were arrested for. But I may be missing something very fundamental.
Right, and I think that I may have been grafting the legitimacy of calling it a Shepard document as therefore it's reliable, and that's a mistake because, as you point out, it is not necessarily something that is reliable because of that difference between what people are charged with and what they may be. So I am changing. If you're wondering if I'm changing my answer to Judge Quattlebaum's last question, I am changing my answer to that question for the very reason that you pointed out, Judge Harris. I know that I'm just about out of time, so I hope to address the other issue in this case in rebuttal. And
thank you.
Any other questions, then I'll reserve the remainder of the time.
Ms. Washington?
Please unmute yourself, Ms. Washington.
These days I'll get this right. May it please the court, my name's Lisa Washington. I represent the United States.
Excuse me, I'm not seeing your colleague anymore.
Good afternoon, my name is Lisa Washington. I am representing the United States in this matter. I'll just get right to the last argument that Mr. Boyd made in terms of the Shepard documents available for the court's review in determining whether or not his predicate drug conviction qualified as a controlled substance offense. The government disagrees that the sentencing sheet is the only Shepard-approved document available for the court's review. This case does not present the same factual scenario as that presented in McLeod nor in Williams. Under state v. Scriven, yes, ma'am.
Counsel, so this is about the using the indictment?
Yes, Your Honor.
All right. So I have sort of the same question I did about arrest warrants. Like, if you if you can just explain to me kind of at like the common sense level, right? Under Shepard, what we need, and I will answer the question I asked your colleague, it has to be certain. Shepard uses the word 3 different times, necessary certainty. We have to be certain of what this person pled guilty to. And I guess I am just not understanding why if we know he didn't plead guilty to the offense as charged in this indictment, like the one thing we know is he did not plead guilty to a second offense of anything. So once we know that, I don't understand what evidentiary value this piece of paper has. We know this wasn't the basis for his plea, so who cares what else is on the piece of paper? Do you know what I'm saying? Like, how does this help us to figure out? All we know is that he applied, unless you're relying on the sentencing sheet, but you're saying we don't have to rely on it, we can just use the indictment.
I'm saying I'm sorry, Your Honor.
Oh, no, you're not saying that. You're saying we need both.
Correct, Your Honor. I'm saying the court was correct in relying on both the sentencing sheet and the indictment.
Well, in your brief, you said the court, hang on, in your brief, you said the court only relied on one and that you were not conceding the indictment, but the district court didn't rely on it, so you wouldn't address it. And then 2 days before argument, you submitted a 28J letter changing your mind and introducing a new argument, all of which is fine with me, except it does seem odd to me that you're doing that in a case where you're saying the defendant abandoned an argument that he introduced only by way of a 28J argument.
I understand.
Sorry.
Yes, Your Honor, I understand completely. The basis for the government's initial argument was basically tracking the language that the district court used in reaching its ultimate determination as to what the conviction was for.
I'm happy to consider your 28. I am totally happy to consider your late-breaking argument. I just hope we will, do this in an even-handed way.
Absolutely, Judge. The district court made clear at the sentencing hearing that it was specifically relying on the sentencing sheet, but that it had considered the indictment, and the government believes that it was correct in doing so. This is not a McLeod or a Williams situation. This defendant, under State v. Scriven and State v. Burden, pled guilty to the lesser included offense of possession with intent to distribute marijuana when he pled guilty to the first offense. So it's not a different offense. That does not render this defendant's indictment irrelevant for sentencing purposes.
But so long as we can tell from the sentencing sheet what he pled guilty to. But your argument presumes the elements of the offense in the indictment are the same as the elements of the offense to which he pled guilty, and we know what that offense is from the sentencing sheet.
Correct, Your Honor. We know what that is from the sentencing sheet. I'm sorry.
So unless the sentencing sheet makes clear what he pled guilty to, then we really can't use the indictment. If we think under this sentencing sheet, maybe he pled guilty to a first offense of conspiracy or purchase, then we can't really use the indictment anymore.
Your Honor, I think a combination of both documents can be used by the court in determining by a preponderance of the evidence what the defendant pled guilty to. On the sentencing sheet, in the upper right corner, it references the indictment, and the 2-line beneath it says that, or just above the 2-line says, in disposition of said indictment comes now the defendant who was pleading guilty to this drug offense. At the very end of that line, there's the WID/first offense, which was critical to the district court's determination that this defendant pled guilty to the lesser included offense of possession with intent to distribute marijuana first offense. I don't think that the sentencing sheet is unlinked to the indictment, especially in this case where the statutory language is the same, the CDR code section is the same, the statutory code section is the same, and while this document in and of itself is not, I'm sorry.
Counsel, the CDR codes are different. When the sentencing sheet refers to the indictment, it uses CDR code 0187, and when it refers to the actual offense of conviction, it uses CDR code 0186. So
right.
So according to this sentencing sheet anyway, the codes are not the same for the two offenses.
The codes are not the same, but they're consistent with the offenses. 187
I thought you said the codes were the same. Okay.
187 is consistent with a conviction for PWID second, which is what the defendant was charged with in the indictment, and 186 is consistent with the code, with the offense for PWID first, which is what the defendant pled to. And Your Honor, that was discussed during the sentencing hearing. I believe the defendant conceded at the hearing that those codes apply to those respective offenses, and he's done so in his brief as well.
Counsel, can I?
Go ahead.
Is that okay? I wanted to ask you about, in your brief, you talk about a case from the Fifth Circuit, which somehow also encountered a South Carolina sentencing sheet like this, and the same argument was made that it's just a statutory identifier, that it's shorthand, and the Fifth Circuit rejected that argument and said we can tell from what's on the sheet what was, what he pled guilty to, and everyone signed underneath it, so we know that it, is sufficiently particular and not just a general category. What's the implication of that for our analysis? Obviously the Fifth Circuit doesn't bind us, but I'm a little wary of disagreeing with another circuit on this, but maybe I shouldn't be.
Well, Your Honor, I would point the court to United States v. Kershaw. It's an unpublished decision of this court, confronted with the same set of facts. Actually, the exact description that's contained on Mr. Boyd's sentencing sheet was at issue in Kershaw. In that case, this court concluded that the district court did not err in relying on Kershaw's sentencing sheet, which identified the offense by name, the conviction by name, the statutory code section, and the consistent CDR with each respective offense, the offense charged and the offense to which the defendant, Mr. Kershaw, pled. This court affirmed the district court's determination that Mr. Kershaw, based on those factors, had been convicted of a predicate controlled substance offense. So to the extent that the court is concerned about whether or not these sentencing sheets are reliable, and granted, Your Honors, we've had a time dealing with them also, and I know this court has been confronted with similar issues in the past. It's just recently in the Williams case. But I would recommend I would rely on Judge Gregory's description of sentencing sheets, particularly it was a South Carolina case. The observation he made in United States versus Young is that while they're not perfect, error here and there does not render the entire document unreliable. It's not fatal in terms of determining what the offense of conviction was. It's just a casualty of what we often call the hurried and yes, Judge Harris.
Counsel, so I do want to give you a chance to respond to what I take really to be the thrust of your colleague's argument, and it's not really addressed in the brief, which is that this is not like the case where there's a mistake. It's just that this particular sentencing sheet just doesn't really tell us anything, because the only thing that might tell us something is because he didn't check that he's pleading as indicted or to a lesser included offense. So we can't just look at the indictment. And so we have to look at the language after the two line, and that language is just literally word for word identical to the generic description of CDR code 186. And so I want to give the government a chance to, and that it would be unusual language to pick if you were trying to describe his offense, because it refers to manufacture, it refers to a bunch of drugs that obviously weren't at issue. So this obviously wasn't something someone typed in specially for him, because you wouldn't pick this language. So, I mean, I really want to give the government a chance. Like, it could be that there is a well understood practice that you don't use this generic language unless the offense actually did involve, say, either manufacturing or possession with intent to distribute. That they are careful only to use that language when it matches up with the actual case, and that in other cases they will write something in. But I didn't see anything like that in your brief, and so can you tell me if there's something I'm missing, if there's some reason to think that this is more than just a generic, like we didn't know what it was, so we just typed in literally word for word, like bizarrely placed comma for bizarrely placed comma, the generic definition.
Well, Your Honor, I don't think I'm comfortable saying that this is a practice of the state courts in Richland County nor in South Carolina. I will say, though, that the exact description as typewritten into Mr. Boyd's sentencing sheet was the description at issue in the Kershaw case. I also, Your Honor, would add that I don't know that I necessarily agree that there was not, this doesn't fall into the category of an error. If you look at the indictment at JA 191, there's a form. It looks like a pre-printed stamped form where a defendant who waives presentment of an indictment to a grand jury is to sign and witness, okay? That is completely blank in Mr. Boyd's case. On the sentencing sheet, the only indication that he waived presentment to a grand jury is the X box marked next to those words. There's also a line for his initials. That is left blank, which leads me to believe that the box marked X was an error. What the clerk should have checked X was lesser included offense. There is no indication that this defendant or Mr. Boyd pled guilty to or waived presentment of an indictment other than the straight X marked on the sentencing sheet. What the other evidence does show, and it's not conclusive, admittedly, but it does show that the defendant pled guilty to a lesser included offense. Your Honor, this case presents the same factual scenario as that. I hate to keep going back to it, but it does present the same factors present in the Kershaw case. And it's not conclusive, but the standard, Your Honor, is not beyond a reasonable doubt, is proof, it's by a preponderance of the evidence. The district
Shepard says it's certainty. Shepard says necessary certainty. Because what we're doing when we do the modified categorical approach is we're substituting for the certainty we would normally get from a conviction. That's really good. You're convicted of a statute and the elements are a perfect match. We know 100% what happened. And this is supposed to be a substitute for that. And the court was really careful in Shepard to say, no kidding around. It has to be certain, that is certain. And I just feel like at some point, what do I know? I am inclined to agree with you. The most natural inference from this paper trail is probably he was charged with PWID second offense and he pled to PWID first offense. I think that is the most natural inference if you put all the paperwork together. But then you're going to have some weird stuff like boxes that were checked wrong. The sentencing sheet doesn't quite say that. I feel like at some point we're getting a little bit far afield from where we were supposed to be with the modified categorical approach. And I also feel like this is not a huge burden in that in most cases, once we're down to sentencing sheets, this is already a hard case. We're supposed to have, ideally, a plea agreement, a colloquy. This stuff, at least in my limited experience, is usually way clearer. We're already kind of pushing our luck a little bit because nobody expects old state records to be perfect. But here we are, and I'm sorry, this isn't really a question, it's a concern. Maybe I'll just let you address it.
Your Honor, trust me, I think my office understands the court's concern. I think this was raised in the Williams case. We are fortunate in that we have in our offices throughout the district special assistant U.S. attorneys who are employed by state and local prosecutors' offices. They have firsthand experienced the difficulty that arises sometimes when we are confronted with Shepard documents and indictment or sentencing sheets and indictments that are present here in the Boyd case. The problem is that once it makes it to federal court and we're dealing with it at this level, it's kind of too late. We're always behind. Hopefully, given the communications between federal law enforcement and U.S. prosecutors and state prosecutors, we can at some point help lessen the incidences that lead to conversations or discussions like this or appeals like this. Given the fact that local and state prosecutors understand now the significance or the importance these documents play at federal sentencing, I think that we can expect that the sentencing sheets, or that they will realize and communicate to their colleagues on the state level the importance of getting it right, because that's what we all want to do. But at the same time, we recognize where we are at this particular stage, and I would invite the court to consider the factors present in Kershaw and factors present in Young. These documents are not perfect, but considering the documents as a whole, and the government stands by its position that the sentencing sheet in combination with the indictment establishes by a preponderance of the evidence that Mr. Boyd was convicted of PWID first offense in violation of the South Carolina Code, and that offense is a controlled substance offense under 4B1.2. Unless there are any other questions about the first issue raised by Mr. Boyd, the government would move forward to the Borden issue.
So I'd like to ask a question on that, counsel, and because you don't have a whole lot of time left. Assume we don't find the defendant has abandoned the Borden issue, and you're at the merits. What's your position on whether assault with intent to kill can be committed with a reckless state of mind or not?
Assault with intent to kill cannot, Your Honor. The cases cited by the defendant in his brief for that proposition all are older cases, number one, and involve conduct that the courts, whether it be the South Carolina Supreme Court or the Court of Appeals, have described as the type of reckless conduct that Borden specifically declined to address. That is the wanton recklessness, depraved heart, malice, foresight type recklessness. The defendant in State v. Smith, which is an 1847 case, shot a person at an open-air festival, person who was riding a horse. He missed the intended victim and instead hit a bystander. The jury declined to find manslaughter and found the defendant guilty of murder, in part based on the inference that the conduct was so reckless. They described the conduct as wantonness, wickedness, depraved, and malignant spirit of the act. That's why the inference was, there was a permissible inference for the jury to find malice in that particular case and find and convict the defendant of murder instead of manslaughter. In Mouzon, what Supreme Court? Okay. I'm sorry.
No, I was going to ask you to address that case. Perfect.
Okay. In Mouzon, in a Supreme Court 1957 case, in what would typically be a felony DUI today, two young 20-something-year-old defendants were convicted of murder and accessory after the fact, based on conduct that the court found reckless and wantonness, indicative of a depravity of mind and disregard for human life. The type of extreme recklessness that Borden specifically declined to address. In the third case, it was a family court case.
Can I stop you on Mouzon just for a minute? Because I will tell you the language that I thought was, that sort of gave me pause, is where they say you don't need any ill will toward the individual who was injured. It's enough that you have sort of a generalized malignant recklessness. And that seemed to be sort of exactly at least in tension with and perhaps in conflict with Borden, which says that you're not using force against the person of another unless you have targeted that person. And Mouzon says, just clear as day, you don't have to actually have targeted the person you injured. And so that's the particular concern I have.
In the Mouzon case, there was trouble. Your Honor, I'm out of time. May I answer your question?
Please.
Yeah, keep going.
Yeah.
In the Mouzon case, Your Honor, like I said, it involved a felony DUI. The problem there was no evidence of assault with intent to kill. And I think that's the tension. In most of the cases cited by, or in the three cases cited by the defendant in support of his argument that recklessness can infer malice, there is no intent to kill. That's different in terms of assault with intent to kill. There is.
But your whole brief, I thought your entire brief was reasoning from, I may have misunderstood. I thought your brief told me the mens rea for assault with intent to kill is the same as the mens rea for murder. And we all know murder is a crime of violence. So go with you're the one who brought me to murder. I was looking up AWIC cases, but your brief said, no, it's the same as murder. And I said, okay, let me look at the murder cases. But are you now saying it's not the same?
No, I'm saying the mens rea is exactly the same, but in Mouzon, in Mouzon, the court found the malice inference based on reckless and wantonness conduct, which indicated a depravity of heart. That is not the type of ordinary recklessness that Borden addresses.
Okay.
Yes. Have I answered your question, Your Honor?
I think so, but I want to make sure my colleagues don't have questions.
I don't have any questions. Thank you, though.
Thank you very much. And I think, Mr. Leonardi, I think you have rebuttal time. Yes.
Yes, I mentioned that I wanted to reach this AWIK issue, and I do, but I briefly want to go back and talk about the Kershaw case. Something critical in the Kershaw case that is not present here is that there was a reliable additional Shepard document in Kershaw, the indictment. And in the Kershaw opinion, this court noted that actually the opinion actually says that the sentencing sheet says that he was convicted of PWID marijuana. Of course, marijuana or PWID does not appear on that sentencing sheet, but the indictment did. And so that's a core difference. And just briefly, I'd like to go over this court's recent decisions regarding these sentencing sheets and point out how unique the circumstances are here. Williams, the most recent case was before the court. There was a sentencing sheet that did not have the generic CDR language. It said PWID crack cocaine. In Furlow, of course, as I mentioned at the top, there was a plea transcript that made perfectly clear what Mr. Furlow had been convicted of. In Marshall, the sentencing sheets indicated PWID and PWID within proximity of a school. Those were the either handwritten or typed in. It was not the whole CDR code. There were two convictions, I believe, in that case. In Sultan, 2018 case, the defendant conceded that the Shepard document showed he was convicted of PWID meth. I think the only case that this court has said these Shepard documents are not sufficient is in Rhodes, and it bears examining because in Rhodes, this court said these Shepard documents are not sufficient because the indictment in Rhodes set forth crimes that were unquestionably within the scope of controlled substance offense and also outside of it. There was distribution and maybe manufacturing, but then also possession language. And so in Rhodes, the court said this Shepard document, legitimate Shepard document, but it's not clear based on this document what specific crime under this statute had been committed. Turning to unless there are any questions about that first issue, I'll turn to the assault with intent to kill issue.
Can I ask you on assault with intent to kill?
Sure.
You filed objections to the PSR. You in particular filed objections to the PSR in the district court. And on page 180 of the JA, footnote 4 of your objections, you specifically objected to the use of AWIC as a crime of violence on the ground that the Fourth Circuit has held recklessness as an insufficient mens rea for a crime of violence. And you talk about other cases that are similar and that the Fourth Circuit would not find recklessness sufficient here. But then on appeal, you specifically abandoned that argument. So why shouldn't we consider that a knowing waiver? You clearly knew you had this argument, but you decided not to make it.
Yes, and candidly, I had forgotten that I had included this back at that time.
That's fine. Nobody cited it in their briefs, which is why I wanted to mention it.
It was with respect to a different statute. It looks like it was an ACC, and I understand that the ACC and the career offender analysis is going to be the same. And so looking at this point, I don't know that I can say that certainly it appears as though that argument was made at the district court and then not raised initially in the initial round of briefing. That appears to be the case. Notwithstanding that, of course, under the court's decision in Manning versus Caldwell for the city of Roanoke, even if the court were to find that an issue was waived, if it meets other requirements, in other words, that There's an adequate basis in the record to address it. It's a legal decision, and that neither party was prejudiced with respect to that issue, then the court could still choose to address it. It certainly is something that litigants will want to know for sure in this district whether assault with intent to kill and other malice offenses would qualify as crimes of violence. My last few seconds here, I just want to make sure that I say that murder is not going away. Malice may be the intent that is required for murder, but it's an enumerated offense too. So regardless of what the court does with malice as on the force clause, murder is still going to be in there. I will also say in the last 2 seconds that I don't believe the government raised the issue of extreme recklessness and that AWIK was not addressed by the Borden decision. I don't think that footnote in Borden was raised until today. Unless the court has any additional questions.
I hate to do this on the last argument when we're over time. So I'll probably, if we were in person, I would be getting kicked. But to your point about murder isn't going away. I mean, if you I think it's the Tracy case, which is a murder case, it does have some of the same sort of recklessness language in there. And if you're conceding that doesn't apply to murder, how do you concede it does apply here?
Because I think that when you look at the enumerated offenses, it's a different analysis than you would have with the force clause, which is what we're dealing with now. I think we need to look at you need to look at what the generic definition of murder is. And if it's consistent with what the South Carolina definition is, then murder would remain a crime of violence.
Okay. Because Borden is only about the force clause and whether you are can be said to be using force against the person of another.
Exactly right. Exactly right. It does not address the generic definition of that.
Okay. Okay.
Thank you. Appreciate it.
Great.
Thank you.
All right. Well, thank you both very much. We appreciate you being here today. We're sorry we're not in person so that we can't thank you in person, but we hope we will see you in Richmond before too much longer. Thank you. And we will now ask that court be adjourned.